Good morning, everybody, and sorry for the delay. I'm glad we could build up the anticipation for this first law and policy meeting today. Today is April 17th, 2024. Welcome again to today's meeting of the Law and Policy Committee. Ms. Linker, can you please take the roll?
Commissioner Baker.
Here.
Chair Silver.
Here. Excellent. Well, for those of you who are expecting to see Chair Matich, I just want to let you know, my name is Adam Silver. I am the newly appointed chair to the Fair Political Practices Commission. I can tell you it's an absolute honor to be serving in this role at the commission where I started my career years ago. I have a deep respect for the FPPC, its work, and its purpose, and I personally believe the commission and its staff and its commissioners to be a true asset to the state of California. So I'd like to thank the governor for this tremendous and humbling opportunity to be at the helm of this important agency at a time that's critical for public trust and democracy, and that's an obligation that I do not take lightly. I also want to thank my predecessor, Chair Rich Matich, now the Honorable Rich Matich. Congratulations, Rich, on your appointment to the bench. I can confidently say our loss is the Superior Court's gain. And then lastly, I want to thank my fellow commissioners, in particular in this context, I should say, Commissioner Baker and commission staff for the excellent work that they've done on legislation over the past several years to further the purpose of the act and the commission. I know our press guy, Jay Waringa, I think that's his official title, press guy. He does an excellent job highlighting these achievements, but really, I think it's important just to emphasize how significant they were in terms of promoting transparency, streamlining reporting and disclosure, and then strengthening the conflict of interest rules. So I really commend you on all those achievements, and I'm really excited to work with all of you to build upon that strong foundation that you all built. So I was going to move on to item one, unless Commissioner Baker, you have anything to add?
Thank you, Chair Silver. Just a warm welcome. It's a pleasure to get to work with you. Thank you for acknowledging the good work of Chair Matich and wishing you well in your coming term. Just looking forward to it and happy to get to work with you.
Thank you. Appreciate that. Okay, well, let's move on to item one, and that is going to be public comment that is related to an item not on the agenda. Looks like we have no public comments, so we're going to move along to item two, which is going to be approval of the March 2024 minutes.
Move to approve.
Excellent. Second. So go ahead and take roll, Sasha.
Commissioner Baker.
I don't know if we have to do public comment on approving the minutes, perhaps not, but I do an aye vote.
Chair Silver.
Aye. And that's an excellent point, just in case anybody does have public comment on the minutes. It doesn't sound like we do, so we'll go ahead and move forward. So let's move on to our third item, and that's a legislative update by our Senior Legislative Counsel, Lindsay Nakano. Welcome, Lindsay.
Thank you. Good morning. Welcome, Chair Silver, and good morning, Commissioner Baker. There are 21 FPPC-related bills that are active now, so I will give updates on many of those today. On commission-initiated bills, AB 2631 relating to the FPPC's online local ethics training program was placed on the suspense file in the Appropriations Committee. That bill has costs of $234,000 in the first year, $227,000 in ongoing years for one IT position and education software. SB 1404 relating to lobbying audits was amended to cap the amount of the new fee that would fund the lobbying audit program at $500 per lobbyist. The bill also adds that those lobbyists who are, that fee would only be charged on lobbyists who are subject to audit. So it would exclude placement agents, lobbying firms and lobbyist employers that employ only placement agents, as well as firms and employers that have less than $1 in payments during the reporting period. The bill was heard in the Senate Elections Committee and passed 5-0, with Senators Nguyen and Newman not voting. I was present as a support witness, and the Institute of Governmental Advocates, which represents lobbyists, was in opposition. The bill is now in the Appropriations Committee and is on suspense. Any questions or discussion before I move on to other commission related bills? Yes, please go ahead.
Thank you. Just quick, you mentioned that Senators Nguyen and Newman did not vote on the bill. Did they express on the record any questions or concerns that you can share with us now?
Senator Newman expressed in the committee hearing that he was swayed by the arguments of IGA relating to keeping the audit workload with FTB and some other arguments, but the main gist of it was agreeing with IGA that those audits should stay where they are.
And without Senator Nguyen's vote, was it otherwise a bipartisan vote? Do you recall? It's okay if it's not at your fingertips. I can look that up.
I think Senator Nguyen is the only. Well, I'll double check on that.
Okay, that's totally fine. Thank you very much.
Yeah, and Lindsay, just a quick note on that one from my end. I went ahead and went back and watched the oversight hearing that the elections committee did last year on this issue, and then I watched the elections committee meeting that you just talked about, the hearing. In my opinion, I just think it's unacceptable that the state's not complying with this requirement. I think it's incredibly important that these numbers be audited and confirm that they're correct. One item that was not brought up in that meeting is the fact that public officials rely upon the information that's provided in those reports in order to properly and accurately fill out their Form 700s. And that's also going to go for the public. They look to those lobbying reports to confirm that public officials are disclosing the correct amounts of gifts that they're receiving. So just another reason why it's incredibly important that this important requirement be satisfied. And I know there was a mention that there may not be abundant evidence demonstrating that these audits would lead to show potential violations. I can tell you from closely following lobbying violations in other states, this sort of activity, if you do not, audit it, if you don't track it, you don't take it seriously, it will arise. And we saw in the state of Illinois, you had the speaker, I believe, of their assembly, getting a real tricky situation with a lobbyist for an organization there. And ultimately, they were prosecuted by DOJ. And that's just one of many, many circumstances where you see, these sorts of situations. So this is something I take very seriously, and I think Commissioner Baker does as well. And it's a priority for me.
Thank you. If there's no other discussion, I'll move on. First other commission-related bill is AB 2041. This relates to use of security, campaign funds for security expenses. That bill passed in the Assembly Appropriations Committee 13-0, so that bill's moving along. AB 2573, which clarifies that the services of a fellow provided by the Asian Pacific Islander Capital Association to a state agency or the legislative branch are not gifts under the Political Reform Act. That bill is set for hearing in the Public Employment and Retirement Committee today. Staff are exploring the possibility of broadening the clarification in the bill to the services of fellows provided by all 501c3 nonprofits to state agencies, since that is consistent with FPPC advice. And the author's office has indicated interest in that idea, so we are working on refining some language. On AB 2803 regarding the
Commissioner Baker, go ahead.
Please go ahead.
Thank you. I should probably use the raise your hand function, but you can see mine. So just on this bill, while we're on it, as you're looking at the language, as it continues to evolve, two things to highlight that you're probably already very much on top of. One is in writing it more broadly, it sounds like it's going to cover more instead of less, which is good because we want to make sure we avoid the situation where they've written it in such a way that they inadvertently narrow it. When you specifically call out that one particular one is not a gift, even though you already have language that says that, you don't want there to be any conflict with, well, if you don't have it enumerated, there's some confusion. So I'm sure everybody's on top of that. Perhaps it's moot now since it sounds like it's getting broader, which I think sounds like it's not necessary, but better than being narrow. The second point is, it sounds like you mentioned that it's being potentially broadened to cover fellows provided by 501c3 organizations. I confess I can look at the bill myself and see what the definition of fellows is. But of course, there are fellows provided by nonprofit academic institutions or interns provided by nonprofit academic institutions, the University of California, Cal State, obviously the Assembly, Senate, and Assembly and Senate Fellows Program. I just want to make sure that those are not inadvertently made a problem or a gift potentially, that they're not excluded when it sounds like the law already includes them as a non-gift. So I want to highlight those as well. I don't believe those are 501c3s, but they are major sources of interns, paid and otherwise, and fellows. Thank you.
Excellent. I think those are great points, Commissioner Baker. And, you know, I agree with the language that's suggested here in terms of expanding it. You know, of course, I don't want to create a sort of exception that can be exploited, but I think it's probably not productive to have carve outs for each one of these fellowship programs that go on in the Assembly and the Senate. I know there's already a carve out for CCST, the Capital California Science Technology Fellows, Capital Fellows as well, in another context. And I think this is a you know, an important clarification that allowing these programs to exist aren't going to result in impermissible gifts to legislators. Really, the benefit, in my opinion, is to the people of California. I mean, these Capital Fellows, CCST Fellows, Maddie Fellows, just to name a few, are just an excellent resource, I think. But of course, we want to make sure it's well regulated and all this activity is disclosed.
Thank you both for those comments. We'll look at the definitions and the breadth of the bill to make sure we're appropriately inclusive and capturing the kinds of organizations we want to, including universities and things like that. All right. Next bill is AB 2803. This relates to the use of campaign funds for criminal defense. The bill is set for hearing in the Assembly Elections Committee next week on the 24th. It was amended last night to replace crimes of moral turpitude, dishonesty, or fraud, instead with a felony described in a certain section of the Elections Code or any felony involving fraud. And I'll read the crimes that are cited in that Elections Code section. Those are felonies involving accepting, giving, or offering to give any bribe, the embezzlement of public money, extortion or theft of public money, perjury, or conspiracy to commit any of those crimes. So the bill would prohibit campaign funds for legal defense for any of those listed crimes. The Commission had other questions about the bill. The amendments do address some of them. The author's office clarified that they intend the bill to apply only to criminal convictions, so some additional refinements in the language are still needed. So we will continue to work with the author's office on that. Next bill is AB 2990, FPPC enforcement actions relating to putting time limits on administrative and civil enforcement actions. The bill was amended to provide that the new time limits would apply only for violations occurring on or after January 1st, 2025. The bill is set to be heard in the Assembly Appropriations Committee on April 24th. Next bill is AB 3239. This is relating to the use of campaign funds for emotional support animals in the context of airline travel. This bill is new since last month's Commission meeting. It was introduced by Assemblymember Carrillo. The bill would allow campaign funds to be used to pay or reimburse airline travel expenses related to an emotional support animal belonging to and traveling with an individual whose airline travel may be paid for or reimbursed by campaign funds. The bill cross-references a definition of an emotional support animal from the Health and Safety Code, which defines the term to mean an animal that provides emotional, cognitive, or other similar support to an individual with a disability and that does not need to be trained or certified. These costs would be reported on campaign statements. Next bill, SB 948, relating to the treatment of general election contributions after a candidate withdraws their candidacy before the primary. That bill is set for hearing in the Senate Elections Committee on April 30th. At last month's commission meeting, the commission paused a regulation project that addressed two scenarios, one of which is currently addressed in the bill. And the commission asked me to reach out to the author's office on the second scenario addressed by the regulation project. The author is interested in addressing that issue as well. I haven't seen language yet, but I will keep this committee and the commission updated on any developments there. SB 1111, which is in the area of Section 1090, would create a new remote interest for certain family members' financial interests. That bill is set for hearing in the Senate Elections Committee on April 22nd. All three of the bills introduced by Senator Hurtado passed out of the Senate Elections Committee yesterday. Those are SB 1151 relating to the registration and reporting requirements for foreign agents, passed unanimously 7-0. SB 1155 relating to post-government employment restrictions for former heads of state administrative agencies. That bill passed 6-0 with Senator Menjivar not voting. The author accepted committee amendments which will clarify that the bill only applies to appointed officials who received a salary from their appointment, not every appointed official. SB 1156, also by Senator Hurtado, relates to financial disclosures for groundwater sustainability agencies. That bill also passed in the Senate Elections Committee. The bill is still a work in progress. The general goal of the bill is to increase transparency by making Form 700s of the board and staff of groundwater sustainability agencies easier to access. And we are exploring options, including potentially requiring those individuals to file directly with the commission using the commission's electronic filing system. Under this option, those statements would be available in one place and would be much easier to find rather than going to each individual agency to search for those statements. I believe there's over 300 groundwater sustainability agencies. Next bill, SB 1170, relating to use of campaign funds for mental health expenses. That bill is set for hearing in the Senate Elections Committee on April 30th. The author's office and sponsor reached out requesting technical assistance with amendment language that they think is responsive to some of the questions that the commission raised about the bill last month, including clarifying the timeline during which campaign funds can be spent for these purposes, opening the bill to incumbents whose health insurance doesn't cover mental health services, clarifying what it means for coverage to be denied, and addressing questions about reporting and record keeping. They do understand that the commission has no position at this point and that any assistance provided by staff would be purely technical.
And Lindsay, quick question on that one. Have we received any feedback on what the legislative history was behind explicitly prohibiting use of campaign funds for medical expenses? Hopefully I characterized that correctly.
Our executive researcher has done a deep dive on that. I don't have the findings in front of me, but I can be prepared for that for the commission meeting.
Excellent, thank you.
Okay, moving on to SB 1422. This is by Senator Allen. This bill would expand provisions relating to disclosure of travel payments for elected officials. The bill was heard in the Senate Elections Committee yesterday and passed unanimously 7-0. The California Clean Money Campaign is sponsoring the bill, and there was no opposition listed. The bill expands the existing disclosure requirements to require disclosure for any individual or entity other than a governmental entity or higher educational institutions that makes payments for travel by an elected officer if those payments meet certain spending thresholds. The bill also expands the information that would be disclosed to include the name of the donor, if they had a reason to know that their donation would be used to pay for elected official travel, and the cumulative amount of their donations. Also importantly, the bill would eliminate the 1/3 threshold for disclosure that provides that they're only required to disclose if the travel payments come to 1/3 of their total spending. So the bill would eliminate that provision from existing law.
Commissioner Baker?
Thank you. I'm glad to hear that, there's an author and then this issue will get some potentially get some legislative attention. I do want to understand the 1/3 amount a little bit more, and this may require a little bit of homework on my part with your help. So I'm envisioning a small nonprofit who brings someone to speak to their group on a substantive topic. So I'll just say for purposes of characterization, not a junket. It's not to a fancy place, and it's not a first class ticket or staying in a fancy hotel. It's reimbursing them to go speak to a group on perhaps a very serious substantive matter. If that small nonprofit pays for travel without the 1/3 or any other threshold, will that nonprofit have to currently disclose all the individuals that you're identifying in your summary?
Under the bill?
Yeah,
Is that-
under the current form of the bill.
There is a spending threshold that the nonprofit would have to reach before they have to disclose, and that is a total of more than $10,000 in the calendar year or $5,000 in the calendar year for a single person. So they would, depending on the cost of that travel event, may not reach that threshold, but there is at least a spending threshold, a total spending threshold in the bill.
Okay, that's helpful. Thank you very much. I'm thinking of small groups that are trying to do good things and highlight them and want to see what burden this current version may put on them. So that addresses that question. I think I had one more, but it left my mind. So maybe it wasn't that important. Thank you.
Well, Commissioner Baker, I'll give you a little bit of time. I'll buy you some time to think of that point because, I just want to say I followed this issue closely when I believe Cal Matters put out a story about it. I think it's extremely important that this information be disclosed. I'm concerned at this point as someone who's very new to this position in terms of the practicalities of getting everything done on the forms and figuring out the little potential pitfalls that might come up when you're changing an area of the law. So I'd like to flush those out and get a better understanding of how that's going to work, what impacts this might have on nonprofits, if any, before I go ahead and take a position on it. But in general, I think transparency is a great thing for the FPPC.
Thank you. I didn't need to buy time. I appreciate that good comment, and I would agree. Fortunately, it sounds like we aren't reinventing a whole new reporting system that wasn't already potentially in place. It just wasn't particularly possibly followed, or it had some thresholds that may have allowed for a lack of what was maybe the intent, which is more transparency. But it is important to flesh out some of these implications, and I'm sure various advocates will do that. I think this is a very important to have the transparency for the spending on travel. And I hope that we'll be able to land in a spot that is very workable and accomplishes that.
Agreed. Excellent. I guess next item, Lindsay.
Thank you for your comments. Next bill is SB 1476 relating to the State Bar of California. That bill was heard in the Senate Elections Committee and passed on consent. It will be heard next in the Senate Judiciary Committee on April 23rd. The bill was also amended this week to add Senator Umberg as a co-author. And last, we have 3 bills amending Section 84308. Combine them together to make the discussion a little bit more streamlined. This 84308 relates to contributions to agency officers and disqualification in agency proceedings. First bill is AB 2911. That bill was just amended last night to reverse all of the original changes made by the bill and to instead make only one substantive change, which is to raise the contribution limit in the section from $250 to $1,500. So contributions would have to reach $1,500 before the disclosure and disqualification provisions would be triggered. That bill is set for hearing in the Assembly Elections Committee on the 24th. Second bill on this subject is SB 1181. This bill is by Senator Glazer, of course, who authored SB 1439 in 2022. The bill is essentially a placeholder at the moment for additional changes that are in discussion. Currently, the bill would impose an agenda notice requirement. The bill is set for hearing in the Senate Elections Committee on the 22nd, and I'll keep the commission updated on the substantive provisions as those are developed. The last bill is SB.
I think Commissioner
yes,
Baker
please.
has a comment.
Ms. Nakano, was that last bill going to be on the same topic or a different topic?
The last bill is on 84308, also
Okay,
on the subject.
excuse me, I misinterpreted the polite pause. Go ahead. I imagine, is the first one McKenna or Dodd's bill?
The first one that changed to only requiring a new contribution limit, that's the McKinner bill,
McKenna. Okay.
2911.
Yeah, all right.
And then SB 1181 is Glazer's bill.
Okay.
And then our last in this series is 1243, and that's Senator Dodd's bill.
Okay, thank you. I will quietly listen first.
Just a quick update on this one. This is the bill that would narrow the scope of 84308 in multiple various ways. That bill is set for hearing in the Senate Elections Committee on the 30th. Pause here for any discussion about these bills.
I think, we'll go ahead, Commissioner Baker.
No, Mr. Chair, I defer to you.
Like I mentioned earlier, I'm a little bit new to some of these pieces of legislation. I think it'd be helpful for me and the public to run through at least a comparison of the Dodd bill and the McKinner bill, as well as current law, if that's possible. Hopefully that's not too big of a weight to put on you out of the blue. But thank you for doing that.
Yeah. So the McKinner bill is the easiest one at the moment. That one would just raise the contribution threshold from $250 to $1,500. And then the Dodd bill is much more complicated. This bill would narrow the bill in multiple ways. The first way relates to participants. The bill would provide that a person is not a participant if their financial interest in the decision results solely from an increase or decrease in membership dues.
Mm-hmm.
Second, the bill would change the prohibited contribution date range. Under existing law, the date range is while a proceeding is pending and for 12 months after the final decision is rendered. The bill would change it to 9 months before and 9 months after the final decision is rendered, which means that potentially a person could contribute while a proceeding is pending if it's outside of that 9-month window. This bill also changes the contribution threshold from $250 to $1,000. And there is a cure period in existing law that allows public officials to cure unintentional violations. Currently, that's set at 14 days. This bill would extend it to 30 days of accepting, soliciting, or directing a prohibited contribution. Existing law provides for certain aggregation of contributions when determining whether it meets the contribution limit or the contribution threshold. This bill would provide that in determining whether a contribution has exceeded the limit, the contributions of an agent shall not be aggregated with the contributions from a party or participant. The bill would also make an exception to the disqualification requirements for certain housing development projects. And I did promise to look more into those housing development projects. I admit I haven't gotten to that yet, but I will have that ready for the commission meeting.
Excellent. Any idea from the author's office or just in general as to why they arrived at that $1,000 figure? Is that related at all to the late contribution reports requirement, or just a number?
I haven't gotten any information about how they got to that exact number, but I can certainly reach out to their office and see if they have or what their thinking was on that.
Great. Commissioner Baker, I know you have lots of thoughts on these bills. I'd love to hear them.
Well, thank you. No, I appreciate the good questions, and that comparison was very helpful because these things are changing overnight and things. On the last question that you raised, I guess I would give feedback because and I do need to disclose ex parte communication during my time as interim chair the last few weeks with Senator Glazer.
And I apologize for interrupting you, Commissioner Baker. I also had ex parte communication with Senator Glazer yesterday afternoon.
Great. Yeah, it's always good to try to remember those and keep track of them. Thank you. On that amount, if they raise the limit, which has been the conversation that many of these bills seem to be doing now, whether it's 1,000 or 1,500, or perhaps the Senator Glazer himself is thinking of this. My feedback, and I would encourage the commission to adopt this approach, is to pick a number that's not esoteric. So 1,000, for example, is something that is seen in a lot of other contexts for us. And I have the same feedback if there's going to be changes to the cure period. I don't feel strongly about that. I think 14 days is a quick period, but is workable because local governments meet more frequently than, say, we do. For example, some of them meet every week, some of them meet every 2 weeks. And so to me, a 2-week time period isn't onerous, but if there is going to be a change, that they not pick something that is, this is the only place in the code that this one time frame is at. Maybe that can't be avoided, but I'm trying to just think of common sense compliance. And so whether that means that if there's going to be a raise a limit, that it's $1,000, $1,500 is one that just it is high. You're starting to get high, and it is it's a different number that we don't often work with. I think you get where I'm going with this. Is let's not make something so specific to just this one provision. Compliance can be tricky. And then a question, if I may, and that is on the dues point in Senator Dodd's bill. Can you elaborate on what that's getting at? Who would be affected most likely by an increase or decrease in dues that this particular exception to being a participant comes out? Maybe I need an exemplar fact pattern.
That's something I think I need to reach out to the author's office on as to who their intent was to capture. So I don't want to speculate at this point, but that's another thing I can certainly reach out to them about.
Yeah, because I understand, obviously, labor-related entities, which had some carve-outs in the original bill, they are dues-paying organizations. I'm trying to think of other dues-paying organizations. Is that if someone's a member of, I guess, I don't know if you pay dues for Rotary, or if you pay dues as part of a housing advocacy group that's not labor related. That would be really helpful to know, especially because if this is going to be happening, we want to be able to competently weigh in on the implications of that. Thank you, Chair, for the time on that. Those are my only thoughts. Actually, I have one more. I hope we won't roll back the bill that was passed last year and the significant work the team has done to make it workable. There may be some cleanup provisions that make sense already. Some of them even popped up during our updates on this bill and on the making of the regulations. We had a lot of discussions about strong mayor cities and other points. And so I just want to make sure I hope that there won't be like a whole rework. I hope if there's some cleanup to do, we can do that, and we allow more time to proceed as we can be more informed by real life practices if any other changes come down the road. Okay, that's enough of my voice. Thank you.
Excellent. Thank you, Commissioner Baker. On that last point, I think I'd like to acknowledge the change that Assemblymember McKinner's office made on their bill, really acknowledging that point, right? I think that change really shows how important this rule is in strengthening the conflict of interest rules, right? So I appreciate them making that change. In terms of the threshold, I agree with you on multiple points. I think public officials already have to remember so many numbers. I can tell you, as the former ethics counsel for the Assembly, all the staff had to remember $10 lobbyist gift limit, $50 reporting threshold, $5.90 gift limit with changes every 2 years. You got contribution limits. There's just so many numbers to remember. So if we can use a number, number one, that's already pretty common in the campaign context, like $1,000 that you mentioned for LCRs. I think that's helpful for everybody. I also think that 500 is a reasonable number for several different reasons. I think one reason that I don't know if it's come up yet is when we're talking about contributions, we're talking about First Amendment activity, right? And when you look at the conflict of interest provisions in 87-100, we would essentially allow someone to make a gift to a public official of up to $589 in the aggregate then that public official could go ahead and vote on an item that would benefit that individual. So I think that is a discrepancy that we might want to take a look at and could justify an increase in that threshold. I think it'd also be helpful to know what the basis was for setting that 250 threshold back in the 80s or the 90s, whenever they adopted this this restriction. And then lastly, I 100% agree with you on the fact that we want to adopt a number that has a strong basis in policy, right? We want to be able to point to why we feel that this number is appropriate in furthering the FPPC's purpose and mission, and also addresses a lot of the concerns that both of us, have seen from the regulated community. Commissioner Baker?
Thank you for the good points. Actually, something's occurring to me just to both support and distinguish. I personally I'm not advocating that we advocate for a change in the limit. It just seems to be seems to be happening among the three authors that are working on this issue, or at least two of them. So that was my feedback for that purpose. I'm reminded now, and thank you for this, that the 250 is something that is in a comparable area, right? This bill was originally an expansion of existing law to local elected officials. And so if we're creating, this would be something to think about. If you have one limit for one set of officials and one limit for another, is that again creating the very thing I didn't want us to do, which is great. We got two different numbers now. It depends on who you are. So all part of the conversation that I'm sure we can be having with the authors, and they perhaps are having with one another. I just wanted to weigh in on those points. Thank you.
Yeah, I think that makes a lot of sense. You have the gift limit that changes, like we talked about, every session. The income threshold for reporting and conflicts is right at 500. The gift limit is currently above 500. I think if you were to raise this to 500, keep the income threshold to 500, and perhaps put a solid gift limit of $500, I think that could be a practical way to address this. Just another thing for us to consider, and the author to consider, and the regulated community to consider. So excellent. What else do we have, Ms. Nagano?
That concludes my bill updates, but I'm happy to answer any questions or do any follow-up that you wish.
Perfect. Item
Commissioner
4,
Baker.
I should say public comment. Do we have any public comment on item 3? Was that what you were chiming in for, Commissioner Baker?
Not at all, Mr. Chair.
Okay.
I thought I would, before we get to public comment, I did want to go back to Assemblymember Lowe's bill on the timing of enforcement actions. I think you said that the bill was amended, or perhaps there are amendments proposed, that it applies only to matters after January or 2025, which for some reason in my mind sounded like far away, but it's less than a year away. There goes time. Is that, normally a bill doesn't become effective until the first of the next year, unless it's a 2/3 urgency clause bill. And I realize that amendments to the PRA are generally 2/3, maybe they're always 2/3, but on this, how does that jive with the reforms that we already have in place? I know we had our own time frame. It was very important to me and the commissioners that there be milestones and guideposts in timing that we wanted to stick to. And one of the reasons why this bill has been a little unsettling for me is because we are already on a track that is, by all appearances, working. So how would this amendment affect our own internal reforms, or how does it compare?
So the bill is significantly more restrictive than the enforcement directives that were adopted by the Commission last year in January. The Commission's enforcement directives are goals, and there is discretion for the enforcement chief to take longer time on cases when it's needed. Under the bill, it's a strict 2-year time limit based on when certain triggering actions occurred. Let me pull up those. So those are from 2 years of the commission receiving a sworn complaint or an audit report, or commencing an investigation on its own accord. So that would be a very strict time limit under which the Enforcement Division would now have to resolve all cases. And this is including cases that have years of records that need to be audited or otherwise naturally could take a long time. So there is a concern among staff how this would impact the ability of the Enforcement Division to do their work.
And as of course we had our own catch up on cases within a 2-year time period, I don't quite remember when that 2-year time period was ending. So I wonder if there would be any overlap with that, but well, and of course I feel like the reforms that we made internally had the benefit of feedback from our own team, the people who actually have to implement this, and their representatives, negotiating representatives. So I think that's important to highlight, perhaps with the author as well. Thank you.
Okay, great. Public comment on item 3? Seeing none, we're going to move on to item 4, discussion of items for the May 2024 commission meeting.
I think we'll know what lived past policy deadline. I don't think the fiscal deadline will have happened yet, but I may be wrong. I have to remember when our May meeting is. It's a little off count. It's off the regular cycle, but I don't have a particular item I would bring up specific to May. Perhaps the chair does.
I don't, besides just a general request to the regulated community. We really want your feedback. If you have any thoughts on perhaps the regulations that are on pre-notice for this commission meeting, this upcoming commission meeting next week, or any of these pieces of legislation, we really encourage you to come here. I'm going to have an open door policy. Even though I'm a former FPPC prosecutor, I did work in private practice, and I understand how these laws impact everybody in our in our realm, right, in this political process. So I really want to make sure everybody's heard. The best way for you to be heard is to come to these meetings and express your concerns. So with that, I'm going to move to adjourn.
Second.
Excellent. Will you take roll?
Commissioner Baker,
Aye.
Chair Silver.
Aye.
The motion passes.
Great. Thank you, Ms. Nakano. Your good work. Busy times. Thank you, Mr. Chair, for a good meeting.
Thank you, Commissioner, and thank you, Ms. Nakano. Take care.